Hi everyone, welcome to our third Tuesday webinar on unemployment insurance employee eligibility. I'm Britt Waterman, I'm a senior attorney here at my HR Counsel, and I am also a former unemployment law judge. So this is a topic that is very near and dear to my heart, something I have a lot of experience with, although in only one state, and these, just to prepare you, unemployment is very state specific. I'm going to give you examples from different states, but of course I can't give you an example of every state. So if you have a question and it applies to your state, please, if you are a client, open a ticket. I may not have been a judge in your state, but I can find you an answer very quickly. If you are not a client of ours and you would like to have an attorney or a former unemployment law judge find the answer to your unemployment law question in a quick turnaround time, my HR Counsel is for you. You can go to the contact information on the last slide to find out more about our services. So this presentation is being recorded and sent to all of the attendees, and everyone will be sent a copy of the slide deck to reference as well. I'm going to go fairly quickly. We have a lot of ground to cover. I don't have enough time to cover appeals in this presentation, so if you are looking for information on appeals, please attend our third Tuesday webinar on unemployment employer responsibility in September for my personal tips on how to increase your chances of success in an appeals hearing. This presentation is covering basically all the things that could disqualify someone for from unemployment or the standards they have to meet. Employer responsibility will focus more on why am I being charged for that, or this happened, do I have to pay for that, talking about tax paying and contributing and reimbursing employers, things of that nature. So appeals will be talked about at that September 3rd Tuesday webinar. So today we're going to talk about a brief history and the interaction between federal and state unemployment laws. Like I said, all issues of eligibility, from monetary qualifications for an unemployment benefit account to federal reemployment assistance requirements. And so I'll start just by saying unemployment insurance started as part of the Social Security Act of 1935. And I'll give my unemployment trivia question that I like to ask. So my unemployment trivia question is, what famous movie has a character named after the individual who was responsible for implementing the first unemployment insurance program? And the answer, if you don't already know, is Dirty Dancing. If you've seen the movie when the baby is telling Johnny that her first name is actually Frances, she says, "My father named me after the first female secretary of the Department of Labor." That is correct. That is Frances Perkins. She was the first female secretary of the Department of Labor, and she was also the Secretary of the Department of Labor at the time unemployment insurance started. So she is the godmother of unemployment insurance. The unemployment insurance department federally is still in the Frances Perkins building. So if you watch the movie again, now you know you have an interesting fact. Unemployment, so by the numbers, when unemployment started, just an example of a year, 1940, 5.2 million workers paid a total of 519 million, which doesn't seem like that much now. By 1982, the economy had dipped, and that had doubled. 11.6 million workers paid a total of $20.6 billion in 2009 at the heart of the recession. 20.7 million workers paid a total of $79.2 billion. In April 2020, in just that 1 month during the pandemic, We exceeded all of 2009, and 36 million workers were paid a total of 48 billion. It would have been 80 billion if it were not for the fact that administratively states could not keep up with the requests for benefits. So a little more information about where this money is coming from. Emergency federal benefits, which is also known as EUC, federal state extended benefits, that's benefits that both the federal government and the state government share responsibility for, that gets turned on by unemployment related activity, so that when there's in 2009 or in 2020, when there was a great deal of unemployment, those benefits kicked in. There was the American Recovery and Reinvestment Act, if anybody remembers the extra $25 in Obama money from unemployment back during the recession. So EUC is paid under temporary federal legislation. Extended benefits went up to 53 weeks of benefits in the 2009 recession. And then now with the pandemic, the CARES Act created EUC in 2020, created an additional 13 weeks of benefits. Still happening in some states. Not all states have the extended benefits. In 2009, so usually extended benefits are shared between the states and the feds until the states run out of money, and then the federal government covers the states. And in 2009, it was the full federal government paying everything because the majority of the states were in debt to the federal government, just for some numbers background. So who makes the rules about unemployment? Each state has its own unemployment program, which is why I said every question is going to be, every issue of eligibility is going to be state specific. So each state has its own unemployment program and runs it themselves and makes their own laws. But all of the programs are overseen by the Department of Labor. The states pay the actual benefits. The benefits that are going into employees, former employees' pockets, are coming from the states. That is not coming from the federal government unless there's an extended benefits situation. The federal government pays the administrative costs to the states of administering their programs. The federal government, as you know, does tax all employers. That's the FUTA tax. And the federal government builds up a trust fund that gets transferred in better economic times. So UI is forward funded. The states and the feds are supposed to build up trust funds. When the Fed trust fund gets big enough, money is transferred back to the states. This is very rare. This is very rare that states don't have to start drawing on the Fed trust fund before it gets big enough to be distributed. This has only happened in 8 years since 1954. And where does the money come from? It comes from, as you taxes, or if you're a reimbursing employer, contributing employer, it comes directly from the employer. Only 3 states do employees pay in. Alaska, New Jersey, and Pennsylvania are the only states where employees do pay in and contribute to that. That's something that a lot of your employees, I'm sure, do not know. So states need these federal dollars to run their programs. So states basically follow the federal rules rather than just breaking off and going rogue and starting their own programs. So the federal government has rules that the states must follow in order to get that federal aid. And the states want the federal aid, so they do follow certain federal golden rules. So the federal golden rules are that all money withdrawn from state funds can solely be used to pay unemployment compensation. That money that the tax that you pay quarterly or that you reimburse the state, that goes into the state trust fund, it has to come out and go right into employees' pockets. That money cannot be used for any other state department. your state legislature cannot move that money around for something else. That all that tax that goes in goes right into employees' pockets. States cannot impose excessively burdensome methods of administration. I'm not sure what that would be now. I mean, something that, very complicated computer application, or if they went back to, you have to come down to the office and stand in line, I think that would be considered excessively burdensome, and the feds would cut off the states if they were doing something like that. So to qualify for unemployment, and this is the same in every state because this is the federal golden rule, to qualify, a person must have to have lost a job through no fault of their own, be able to work, available to work, and actively seeking work, and they have to have earned a minimum amount of money before becoming unemployed. So those are the qualifications that are going to apply to every state if they want that federal money. The base period, like I said, you have to, an applicant has to have, and I say applicant, other states say claimant, former employee. That's what I mean when I use that terminology. Must have earned a minimum amount of wages before establishing the benefit amount in order to be eligible. So this period where they measure the wages is called the base period. There's a standard base period, which is the first 4 of the last 5 completed calendar quarters as of the application date. There's also some states allow an alternate base period. Not all states do. It serves to make more people eligible for unemployment. And so if you employed this person in the first 4 of the last 5 completed calendar quarters, or if you use an alternate base period, then you are a base period employer, and you will show up on the wage statement that gets sent out, the monetary determination that gets sent out when this person applies for unemployment. So you will get a monetary determination or a determination of base period showing the wages that you paid in the base period. Don't ignore this. Verify it against your payroll records, because this is going to determine the person's weekly benefit amount and maximum benefit amount. You may get this in the mail and think, well, we don't care if he collects unemployment or not. You really should take a look at this and verify it, because this does determine what they're rightfully entitled to as far as the amount of wages in the base period. And also, as we'll get into in employer responsibility, contributions between base period employers that can prorate their responsibility for benefits. So you want to make sure that you're not affecting other employers. You want to make sure when you get that monetary determination that you look at that and make sure that's right, and that if you don't, you file an appeal immediately. So wages for most, but not necessarily all, employers are counted in the base period, not just the most recently separated employer is in the base period. Sometimes the most recently separated employer isn't in the base period at all. Employers won't show up in the base period if the employee was an independent contractor. Some domestic or agricultural employment, those wages are not used in determining the base period. Some nonprofit or religious employment, those wages aren't used. Determining the weekly benefit amount and the maximum benefit amount, once you have those base period wages, the requirements for wages in the base period is going to vary from state to state. That is not a federal limit. Usually different states, for example, Oregon, you have to have a total base period wages of at least $1,000. Your total base period wages have to be equal to at least 1.5 times the amount in the high quarter or you may qualify if you worked a minimum of 500 hours, even if your base period doesn't meet the monetary requirements, in which case your wages would be reallocated to meet the minimum standard. So it really, usually there is a total base period monetary requirement and a high quarter requirement is how most states do it, but there is a minimum amount of wages in the base period that have to be earned. Maine, for example, 2 times the average weekly wage in each of 2 different quarters, at least 6 times the average weekly wage of the state in the total base period. So they're using the state's average weekly wage to calculate what should be in the base period to establish an account. Waiting week, 42 states and Washington, D.C. require a waiting week. The waiting week is the first week of eligibility. So the first week that they are unemployed and meet all the conditions of eligibility, and that waiting week is unpaid. The history behind this is that states wanted to save money from applicants that who did not exhaust their benefits. Now most states only have a week for their waiting week. At some point, some states took the first 4 weeks as waiting weeks. Their justification was, well, union workers continue to get paid after the layoff, things like that. It was really burdensome and kind of defeated the purpose on providing wage replacement for people who were not bringing in any money. The federal government does not require the waiting week. It is the state's choice. But when there is those federal state extended benefits, as happens during a recession or during the pandemic, the states without waiting weeks have to pay 100% of the first week of extended benefits. So the feds don't require the waiting week. They do give a little penalty to the states that have them. In states that have maximum 26 weeks of benefits, which that is the maximum in most states, the applicants who do exhaust will receive their final payment in the 27th week. Waiting weeks are no longer necessary because of electronic processing. There used to be administrative delays that kind of justified the waiting week. That is no longer necessary. And some states will go back and pay the waiting week if you stay on for a certain number of weeks. When the CARES Act was passed last April during the pandemic, many states eliminated their waiting week, and for the states who eliminated their waiting week, the federal government paid that first week for the states. So the states who eliminated their waiting week got that first week reimbursed by the feds. So what does no fault of their own mean? A layoff or reduction in force always qualifies as a termination or a separation that is no fault of the employee's own. A layoff or a reduction in force means that this employee was not replaced. This is a big difference between a layoff or a reduction in force and a termination. If you separate from an employee and you hire someone to come right back into that position, you did not lay that person off, you terminated that person. For a layoff or a reduction in force, or sometimes for a furlough, the sole reason is a lack of work. Termination for gross or willful, all the other adjectives that it comes to when it comes to separating conduct-based termination into the yeses and the nos that we'll get into shortly, generally never qualifies. Things like committing a crime, theft, assault, that's generally never going to qualify. it depends on what you say is fault. You know, they weren't trying, they weren't doing a good job. Your DOL, DES, DWS, your agency may say, well, you know, no, they couldn't do it. They didn't have the capability, and so that's why they lost the job, and that was no fault of their own. So that's so you may end up disagreeing with your agency, and there may be nothing you can do about it based on their definition of misconduct. Attendance is going to split you in two in some states here. Generally, most states will agree that if someone is showing a wild disregard for the attendance policy and only coming to work when they feel like it, that would be misconduct. But people who have absences that are out of their control, that is generally not misconduct. That's a hot topic. Quitting, as far as no fault of their own, it's extremely fact specific. There are multiple exceptions. The biggest myth in UI is no one can get unemployment if they quit. You're going to find yourself on the defensive here. You may think that this former employee had a choice, that they chose not to work and collect benefits when work was available. They may say it was so illegal or unethical or unpleasant. The bar is generally higher than unpleasant, that no one would have seen it as a choice, that they had no choice. And that's going to have to be determined by your agency. Many other exceptions in other states, they may appear to be awarding someone for walking away, and it is through their own fault, but the law does not always assign fault that way. Striking involved in a labor dispute generally doesn't qualify. Most workers say no, states say no to workers on strike or honoring the picket line of another union. Different states make different rules depending on the reasons for the strike, the length of the work stoppage before returning to work. A lockout is different. If it's an employer lockout, they are eligible. A leave of absence, there's going to be a difference between a voluntary or involuntary leave of absence. A voluntary leave of absence is there is work for the employee to do, but they are choosing not to do it for whatever reason, and they are away from work. Involuntary leave of absence, there is no work that the employee can presently perform. So that is a distinction as far as eligibility in a lot of states with regard to a leave of absence. So you have to think about less about the employee, more about the work. Does work that the employee is able to perform actually exist? And if that work that they can perform exists, that's going to be an involuntary leave or a voluntary leave of absence. So the weekly eligibility requirements, these are, as I said, in all 50 states and Washington, D.C., the employee must be able to work, available to work, and actively seeking work. Now, this is a week-by-week determination. This is not a yes-no, like a separation would be you quit, you're ineligible until you work again and have enough wages to requalify. This, you know, or a no, like you don't have enough wages in the base period. This changes week by week. Someone can be ineligible one week because they're not available for work, and then eligible the next week because they are. So this is a week-to-week requirement. The CARES Act blew this up. They were making people eligible who couldn't work because of quarantine, because of COVID, because of caring for family members. Most states waived their work search requirements altogether. So this kind of all went out the window with the pandemic, and a lot of people who were not able to work or actively seeking work were able to collect benefits. A lot of states, the CARES Act expired. A lot of states have ended their emergency orders and dialed back on this now and are back to their back to these three requirements. So able to work, Generally, this means medical capacity to perform work. If someone's an inpatient or outpatient treatment, that makes them ineligible. Again, like I said, the CARES Act overrode this. Minnesota is the only state where you cannot receive both unemployment and Social Security disability unless you have a note from a doctor or you collected Social Security disability during your entire base period, showing that you are disabled and you can work at the same time. So this is going away in July of 2022, but Minnesota is the only state that does not allow that. If you are collecting unemployment benefits or not you, but a former employee is collecting unemployment benefits and decides to apply for Social Security disability, the Social Security Administration is going to question this and say, you know, every week when you apply for benefits, you're certifying that you're able to work. Now you're telling us that you're not. Which is it? So that's something that can come up as an issue with Social Security and unemployment. Available to work, reasons that someone might not be available to work: caring for a family member, no childcare, no transportation, limiting their geographic area or work hours, or out of town, up at the cabin. They're not looking for work up at the cabin. They're on vacation. They're not available to work. A college student is a little tricky. If an applicant is enrolled in an approved vocational training program that UI has signed off on, this is not going to affect their eligibility. In some states, someone who has been a college student during their entire base period can stay in college and collect benefits. Other states say, no, you can't do both. You have to be available to take work any hours that you're offered. Incarceration, obviously you're not available to work. In Colorado, if you move someplace where you have no job prospects, so if you, I don't know if I guess I can't think of an example. I guess if you live in Colorado and you get laid off from your job as a ski lift operator and you move to Louisiana where there are no ski resorts and no chairlifts, Colorado is going to say that you are unavailable for work. Yeah, and like I said, out of town on vacation, unless you're there to look for a job there and you're going to resettle there, you're not available for work. Jury duty does not make someone ineligible for work. Jury duty is probably the only exception to not being available. In some states, they have to report their jury duty pay and it gets deducted from their benefit amount. In some states, the jury duty pay is not deductible, so it just depends. Actively seeking work. So applicants can limit their work search. They don't have to take just absolutely anything that comes along. They can limit their work search to suitable employment. So what's the definition of suitable? Well, most states do have their own definition, either in the statute or in guidance that their Department of Labor has issued. From Wyoming law, for example, the definition of suitable is pretty standard. It's something is suitable once you've considered the risk to an individual's safety, health, and morals, the individual's physical fitness, the length of unemployment of the individual, the prospects for securing local employment in the individual's customary occupation, and the distance of the employment from the individual's residence. So those are the factors in Wyoming, and you know, like I said, that's a pretty standard test. Those are factors you would consider in determining whether work is suitable and whether an unemployed person needs to be applying to those jobs. However, the longer someone is unemployed, the broader the definition of suitable gets. So you can start out unemployed and say, I'm not taking anything that pays less than my last job. Lower wage work gets more suitable the longer you're unemployed. So the state agency is going to expect that person to accept or apply to jobs with a lower wage the longer they are unemployed. Same with commute, a longer commute than they previously had. They need to be applying to those jobs because that becomes more suitable as the period of unemployment lengthens. Most states put their expectations for a job search right on their website, so that applicants know what is expected to be actively seeking work. Georgia, for example, says we expect a minimum of 3 reportable job contacts a week. You have to keep detailed information about your job contacts. We may audit you at any time. Virginia actually requires applicants to report their job search to the commission. All states are going to have a little different view about what actively seeking is, and some states may make a case-by-case determination, but it has to show a genuine attachment to the labor market to be considered actively seeking work. Union workers who look for work by registering at the hiring hall. This is fine to a point, to just register at the hiring hall. After a longer period of unemployment, they have to add to their search in addition to just registering at the hiring hall. In most states, if an employee's base period is based on full-time employment and they say, I'm only looking for part-time, that's not actively seeking. Employment's not suitable if it's only open because of a labor dispute. So refusals fall under this section in some states, or they have their own section in other states under the law. Refusals are generally not a week-to-week determination. So generally, if you offer someone a job and they refuse it, they will not be eligible the next week. Generally, if someone refuses a job, they will be ineligible for a set number of weeks. So you refuse an offer of employment, you're ineligible for the next 8 weeks or whatever the number is in your jurisdiction. If you have an employee and their base period was based on part-time employment, they only work part-time for you, and you offer them a full-time job, they can say no, and that is not a reason to cut off benefits. That is not suitable employment if they only ever work part-time and you offer them a full-time job. The prospects in their customary occupation also matter. If you're an employee was an admin and you offer them a janitor position after 2 weeks of unemployment, again, that refusal is not going to count. That was not suitable employment, and they will not be cut off benefits for turning down that job. If you are offering them their exact same job that they had previously back then, yes, that is a refusal of suitable employment, and you need to get familiar with your online system. You need to go online and you need to raise an issue and notify your agency that that individual has refused an offer of employment. Separations, layoffs, terminations, discharges, suspensions, voluntary quits, leave of absence. We talked about these. These are the, like I said, the different kinds of separations, and this is something that when someone applies for unemployment, the agency is going to have to make a decision, are they eligible or not eligible based on the reasons for the separation from the employment. If they are not eligible based on the reason for the separation, generally they are not eligible ongoing until they work in subsequent employment and earn enough wages to requalify. So it's generally if someone is ineligible based on the circumstances of their separation, it is a cutoff until you get another job and earn more money. So that is very important when you're getting a determination about the reason for somebody's separation, that you're opening that in the mail or looking at that online and making sure that's correct and appealing that if that's not correct, because that's not going to be a matter of them getting benefits for a week or 2 weeks. I mean, that's going to have a big effect. And layoffs, like I said, always pass right through. So you'll get that monetary determination or that notice this person has filed for unemployment on a layoff, but you are not going to get the questionnaire asking about the reasons for the separation if the former employee writes down layoff on their questionnaire. So if you have a former employee who may have a misunderstanding of the reasons for his separation and you think he may misrepresent it as a layoff, make sure you are on your online system checking to see if he has been put through as eligible, and make sure you're raising an issue. So terminations, misconduct. Misconduct is disqualifying, and like I said, for the certain period of time until they earn enough to requalify. This could be as small as going outside the employer's reasonable expectations. To some states, it has, for misconduct to disqualify the person, it has to be wanton, willful, intentional. In some states, there's misconduct per se. It actually says in their statute, do these things and you will be ineligible. Some of the things: failing or refusing a drug test, like I said, committing a crime, falsifying an employment application, violating the attendance policy within their control. Again, if it's out of their control, they're going to be eligible. Safety violation, insubordination. Those are things that some states have listed right in their statute as if you were fired for this, it's a big no on unemployment. Some states will remove your wages from the base period if the reason for the termination is a felony related to the employment. So that may have an additional penalty if the reason for the termination was a felony related to the employment. You want to make sure that they have that information if that was the case. Some states give zero definition or guidance. It's just going to be the person at the agency who gets your questionnaire, and they're going to make a decision. Whatever you put on the questionnaire, documentation is key. What you put on the questionnaire should match exactly what you wrote in the termination letter, in your internal communication, everywhere that you have the reason for termination written down. Don't play it up. Don't try to mislead the agency. What you put on that questionnaire should match everything else you have in writing exactly. If your employee files a lawsuit against you, opposing counsel is going to hold up every document you've ever written about the termination, and if they don't match, they're going to attack your credibility. So do not exaggerate on the questionnaire from the agency, but do have your documentation and do send it in, and do keep your file on your employees who are problematic, or if there's a certain incident, and send in what you have with that questionnaire, because they're looking at the employee's words, they're looking at your words, and generally in most states, they're looking for a 51% over a 49%. They just, whoever can tip the scales, just that 1% is the person who's going to win. So having that documentation, sending that in, make sure they have all of your side of the story is going to be important. Poor performance, you're going to have a very hard time showing misconduct for poor performance unless it is absolutely intentional. That's going to be a hard one. Voluntary separation, good cause, adverse to your employee and within your control. This is your harassments, your discrimination, you're making the employee do illegal or unethical acts, your whistleblowers, your dangerous working conditions, cutting pay, cutting hours. These are good cause, adverse to the employee. These are reasons that for quitting that an employee would be eligible in every state if they quit for those reasons. There are many exceptions other than good cause that someone could still be eligible. Like I said, most people think if you quit, you'll never get UI. That is absolutely not the case. Other exceptions, if you quit because of illness, if you quit because you are caring for an ill family member, if you quit because of a lack of childcare, again, these may raise availability actively seeking issues. If you quit because you don't have childcare, and then how are you looking for work if you don't have childcare? So if somebody quits for a reason that they can't get to work because they are bound up at home with something, you want to make sure you raise that availability actively seeking issue, because they may be eligible on the quit, but they may not be available and actively seeking. And so you want to make sure that the agency knows about that as well. Half the states have domestic violence exception. Almost every state has a quit to follow a military spouse exception. Someone who does that is going to be eligible. 9 states have a good cause for personal reasons exception. That means the agency is going to look at their personal reason that they give for quitting and determine whether or not that was a good enough reason to quit the job and whether or not they are eligible for unemployment. Again, you're really going to be on the defensive there because because you are not going to be allowed to say whether or not you think it's a good personal reason in those states. If you were accommodating and you were offering that person accommodation and you had a chance to, you were trying to correct the condition that led to the personal cause for quitting, that could help you in that case. In some cases, employees have to complain first. In some cases, they don't. What happens when you have to fire someone during their notice period? They give you 2 weeks notice, and then they're potentially, stealing company secrets or something. You want to discharge them after they gave 2 weeks notice. It varies from state to state. Some will say that the person still quit and is ineligible. Some say they quit as of their notice date. Some will say there was still work to be done at that point and you were the moving party and they become eligible. So if someone gives you a 2-week notice and you say, you know what, we're good here, you can just be done today, that person may be eligible for unemployment because you just now terminated them with no misconduct, even though they just told you that they were going to quit. No call, no show is a job abandonment, or are you firing them because you don't want someone working for you who doesn't call in? A lot of times it's not going to matter either way. A no call, no show could be misconduct and make them ineligible on a termination, or just never showing up to work again could be considered a quit, and that could be a quit without good cause. Putting the phrase, if you no call, you no show, then that means you quit in your handbook doesn't magically make it so in the eyes of your agency. They're going to look at individual circumstances for each individual. If someone no call, no shows one day and calls you 12 hours later and says, oh my God, there was a terrible accident and I was in the hospital, can I please have the next day off? And you say, no, you quit when you didn't call. You quit working here, and you fill out the questionnaire saying they quit. You're not going to get very far with that. Again, documentation is key here, just like with any other separation. Ask for a resignation letter. Do not force someone to sign a resignation letter, especially if it's not clear whether they're quitting or you're terminating them. Do not force someone to sign a resignation letter. That is only going to make you look bad. Exit interviews, you can document those, document any accommodations that they may ask for and any accommodations that they refuse. Part-time workers part-time workers can collect benefits, but they must still be considered unemployed. What is unemployed? Every state defines the word unemployed differently. In New York, you can't file for a week in which you work 4 or more days. If you work 4 or more days, you're not unemployed. So in New York, unemployed means you work 3 days or less that week. In Minnesota, you're not unemployed if you work 32 or more hours in a week. So you could work 31 hours in Minnesota a week in Minnesota, and you'd still be considered unemployed. In Washington D.C., you're not unemployed if you work full time. Does it say what full time is? No. So can somebody be considered unemployed if they work 39.5 hours a week in Washington, D.C.? Maybe. This applies to workers who have always worked part-time and lost one job. This applies if their hours get cut through no fault of their own, if they ask for a reduced schedule to go to school or some other reason they do not have hours cut through no fault of their own, and they should not be eligible if they ask you for a reduced schedule. But no matter how many hours they work or what the situation is, if you're working, you cannot earn more than your weekly benefit amount. States are going to deduct those earnings or a portion of those weekly earnings from the weekly benefit amount. Some states will say, how much did you make this week? And they'll straight deduct that from the weekly benefit amount. Some states have a complicated mathematical formula for determining exactly how much of the claimant's weekly earnings gets deducted from their weekly benefit amount that week. So it goes state by state how much the employee gets to keep of their weekly benefit amount. They are required to report earnings when they request benefits every week. When they request benefits every week, the state will ask them, did they work? And if they did, how much they made. Not reporting their earnings is fraud. If they are overpaid because they did not report their earnings, that overpayment based on fraud can have penalties. When you get those wage detail reports in the mail, send those back right away. Keep up with how much your part-time employees are being paid. Check out your online account. If you've got part-time employees collecting unemployment and they're on your online account and you look and they're collecting their full weekly benefit amount each week, that's fraud, and you're going to need to raise an issue with the agency on that, because not reporting earnings is fraudulent. So if you've got people on collecting UI who are working for you part-time, or if they're working for you full-time, that's a red flag in not every state, but some states. Whatever the cutoff is in your state, you need to raise an issue on those individuals because they are committing fraud. Deductible income, whether income is deductible is based on state law. Severance pay, for example, some states say if you get it in a lump sum, it's not deductible, but if the former employer doles it out in periodic payments, it is deductible. In California, it is never deductible, regardless of whether it's a lump sum or periodic payments. In Texas, if you're receiving periodic payments, you will not get any UI until you are finished getting your severance payments completely. So it really depends. In some states, the lump sum payment, like I said, at termination, it's not going to affect benefits. They consider that lump sum at termination severance as wages that you earned while you're employed. Vacation pay, if you've got an employee on furlough and they're temporarily laid off and you plan to bring them back and you are letting them use their vacation pay while they are on furlough, that is going to be deductible from their unemployment account. I think a few states will make employees use it up first. So in some states it is deductible. You don't get paid unemployment while you still have vacation pay out there, but whether or not that's deductible is just going to depend on states. Some states deduct it all, some states take a percentage of it. It's just going to vary state by state. Pensions and retirements, this is complicated, and whether it's deductible depends on whether it's coming from a base period employer and whether there were contributions made after the start of the base period. There's kind of a formula, so that that's something to look into if you have a pension plan or a retirement plan and your employee goes on UI. You want to make sure that the agency is handling that correctly. If you have an account where the employee is the only one who contributed to the retirement account and an employer did not contribute to the account, that's not deductible. And as I said, no deduction for Social Security except in Minnesota, and earnings always deductible. Reemployment Assistance Services, the U.S. Department of Labor founded this program. It targets ex-service members and those most likely to exhaust benefits. How does it determine who is most likely to exhaust benefits? I don't know. It looks at everyone's application. So everyone who applies for unemployment has to list all their previous employment. Somehow that gets audited, and based on what people have listed about their previous employment or their age or other demographic factors, they get flagged by this reemployment services program. And they say, we think you have the potential to be unemployed for a long time and we want to help you out. So ex-service members and these people who are deemed likely to exhaust benefits are selected for an assessment of eligibility and a potential need for services. The agency will send these individuals a letter saying, here is your appointment. Please go to, they have the DOL funds American Job Centers. Some states call them workforce centers or worker resource centers. They go by different names, but they are there to provide resources to people seeking reemployment. So they are funded by the Department of Labor. They teach people how to write resumes, interview skills, networking, how to look for work using some of the different websites online. They help people free of charge with those skills, people who happen to be unemployed. So people can go to these centers voluntarily, but people who are flagged here will get a letter saying you have to show up at the American Job Center at this date and at this time. And if the person does not go, they are ineligible for benefits that week, and they will send them another letter with another date and time. And if that person doesn't go, they are going to be ineligible for benefits until they show up and attend a session. So you probably wouldn't have knowledge that someone didn't go to their session, but this is something that if they resist this, they could potentially lose benefits for an ongoing period. School employees and athletes, just a quick, this is a federal rule. All states have to have this rule in their statutes to comply with the federal law. Teachers and professional athletes between school years or terms or between seasons, if they have reasonable assurance that they're coming back either by common practice or they've worked here for 14 years and they've come back every fall and nobody's told you any different, or you signed a contract for next season. If they have reasonable assurance, they are not eligible for unemployment between the years or terms or seasons. So thank you all for participating in the webinar today. Again, if you have any questions, you can go to myhrcounsel.com. You can shoot us an email, check out our offerings on our website, and let us know if you have any questions. If there's anything we can do for you. Like I said, if you are a client, please open a ticket if you have any questions about anything I've gone over today. If you are not a client, please go to our website. All of this information that I've shared today would be available to you on demand at any time, and that's just a fraction of what we offer. So thank you all, and I hope everyone enjoys the rest of their day.